Hello, everyone. My name is Alexander Nam, and I'm a law clerk here at Lowes Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Preventing the Revocation of Your Home Health or Hospice Agency from the Medicare Program, Tips on Avoiding an Adverse Action and on Responding to Such an Event. Today's presenters are Jennifer Papapanagiotou and Ashley Morgan. Jennifer's practice focuses on compliance, regulatory and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing business arrangements for compliance with federal and state fraud and abuse laws and drafting a wide variety of legal agreements. She is knowledgeable in all aspects of state licensing for home health and hospice providers and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. Our next speaker, Ashley, is a partner in Lowes Parker's DC office. Ashley focuses her practice on regulatory health care compliance matters, fraud and abuse, and reimbursement issues. She represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion and termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. She's also a certified professional coder and a certified medical reimbursement specialist, as well as a certified medical compliance officer. And as a quick reminder for everyone, if you have any questions throughout the presentation, please feel free to type in the chat box and we'll address as many as possible at the end of the presentation. Also, we will send out the slides as well after the presentation as well. And without further ado, I present to you our speakers.
Thanks, Alex. This is Jennifer Papapanagiotou. Thanks, everybody, for joining us today. Please, Alex, if you can go to the next slide. All right. We're going to talk a little bit today about things that can give rise to revocation actions by the Medicare program. If you're new to this and are saying, well, what's a revocation? It's an action by the Medicare program where they take away your billing privileges. And it's an administrative action that has certain very specific regulations that apply to it, both to when it can be imposed, the grounds on which it can be imposed, and the terms they can place on that and how long they can remove you from the program. And then there is an additional set of regulations that very specifically define how you appeal these actions. So we're going to talk about the revocation reasons that exist under the current regulations. We're going to talk about some practical scenarios where these things happen and what we're seeing right now as sort of the hot topics that CMS seems to be focusing on when it comes to revocation. And then we're going to talk about how to appeal them and some new provisions on what a new action called a stay of enrollment, which is kind of a step down from revocation. We were pleased to see them implement that recently. Let's go to the next slide. All right. So right now, as of today, there are 22 revocation reasons. These are written into a regulation at 42 CFR 424.535. That regulation can be modified through rulemaking. If we still have rulemakings from CMS, it remains an open question to see if they start making modifications to these regulations. Without that, after one of the executive orders that went out earlier in the year. But I've highlighted in red the ones that I would consider to be sort of hottest topics right now. I don't want to read through these in painful detail. I'm going to point out what we see as the most common ones. The third one on this list is felony convictions. If you have an owner or managing employee with a felony conviction in the last 10 years, that is low-hanging fruit for revocation. We've done tons of these cases, and the good news is, if it's something new that happens, you do have a limited window of time to fix these things. But if it's an old felony conviction and it hasn't been reported, or even if it was reported and somehow you stayed in the program and it's within the 10-year window, there's risk of revocation, and that's something you should be talking to your healthcare counsel about. So we'll talk a little bit more about that. False or misleading information on an application. These are the 855A applications or PACOS applications where you report certain information of the Medicare program. That's a very, very active, it has been an active revocation reason for a long time. It sounds like the words say false information. That could be, you know, information that's not accurate that you reported. It could be answering a yes or no question incorrectly and saying no when you should have said yes. CMS views leaving information off an application to be false or misleading. It doesn't have to be done with intention. It can be a simple error or oversight on someone's part, but they consider omitting information to be the same thing as misstating or providing false or misleading information. Let's go to the second page here, the next page. Two other really common revocation reasons we're dealing with now, number 8 being probably one of the most active right now, is abuse of billing privileges. There are 2 categories of abuse of billing privileges. The first is billing for deceased beneficiaries. That was used a lot 10 years ago. They went through and did a sweep where they looked for claims filed for dead people. And if a provider had filed more than 3 claims for a deceased beneficiary, they got a nasty letter from Medicare. Don't see a lot of that anymore. We really see more either what we call impossible services, or what is the most active, which is a pattern or practice of billing errors. And we're going to go into this in some detail, but essentially, if Medicare decides there's been a pattern or practice of billing errors by a provider, they can revoke them. Number 9, failure to report changes. This is anything and everything in your enrollment record that needs to be updated. There is a timeline to do that. And if you move locations, or you have an owner that gets bought out, or literally there's anything in your enrollment record that needs to be updated, there's a window of time to do that. And if you fail to do it in certain circumstances, they can impose a revocation. There's some good news on that front, that the stay of enrollment provision that they implemented, it's been a little over a year, I believe, actually makes this revocation reason less likely. They're more likely to impose a stay now and let you actually do the updates, but that's a conversation we'll focus on a little bit later on. Let's go to the next slide. So the last revocation reason that we're seeing more and more action under, all of these are potential risks. We're focusing on the ones that are the most common. Number 19 here, an affiliation that poses an undue risk. There's a very complicated regulation that was implemented in early 2020 that essentially allows Medicare to, if they see a provider that has certain owners and managing employees, and one of those owners or managing employees has has an affiliation with another enrolled healthcare provider that had a disclosable event, those are all defined terms, then they can revoke these affiliated providers. So if a owner of a home health agency got in trouble with Medicare program and got revoked, and they own other healthcare businesses that are enrolled in Medicare, Medicare can go and revoke those other Medicare businesses. We'll talk a little bit more about affiliation later. Let's go to the next slide. All right. We've tried to kind of give you some practical examples and explain in a little more, sort of global terms, the biggest areas where we see revocations happen and how to avoid them. So the first is enrollment problems, failing to report a change of location, failing to revalidate on time, failing to report an adverse action, having owners or managing employees with felonies. Those are all problems related to your enrollment record and not keeping it up to date usually, or some disqualifying issue for one of your owners or managing employees. Operational problems, which generally are related to failing to do something at your location or in your policies and procedures that endanger your ability to continue as a Medicare provider. Things like failing to keep regular business hours, not having proper signage, and screening and credentialing of your staff members. The last area is billing problems. So reported high error rate claims, claim audits, and PPEO reviews are the big ones we're seeing right now. So we're going to talk about these three different categories. Let's go to the next slide. And the revocation reasons kind of overlap and fit into several of these. So enrollment issues, basically reasons 3, 4, and 9 that were listed earlier, felonies, false or misleading information, failing to report changes, are all sort of enrollment related issues. So you have to report felonies of owners or managing employees within the previous 10 years. If you leave another type of adverse action off of your enrollment record and it's something that's required to be reported, it's in section 3 as an adverse action that you have to report, and you leave it off, that can be a problem that can give rise to revocation. If you move and don't tell the Medicare program about it and they can't find you, you have to report that within a certain window of time. That can get you revoked. Also, failing to remove, and I've seen this frequently, not so much in home health and hospice, but I've seen it a lot in physician practices recently. If you have an owner or managing employee that passes away, you have to remove them from the enrollment record within a certain amount of time, or they will revoke you. Like I said, I've had several of those over the last few years where one of the physician owners of a physician group, for example, passed away, and the practice didn't realize that they needed to go in and remove them off the record, and they got deactivated or revoked. So how do you keep things like this from happening? Well, you keep your enrollment record up to date. You follow the guidance and the regulations, and you do your updates, and you do them timely. I have a couple of tips just for your own sort of practical knowledge about how what's required for enrollment and how to kind of protect yourself in that process. So first and foremost, never use a PO box or a commercial service mail service location as a practice location. That's usually not an issue for home health and hospice, but I have seen it happen with physicians, and specifically physicians that work primarily in hospitals or facilities. Know what your enrollment obligations are. We're going to run you through some of the most important ones here in the next couple of slides. Always, 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 always keep copies of everything you submit to a Medicare contractor, whether you submit it on a paper application or you submit it through PACOS. Print, save, print, save, print, save every single time you submit something. Use trackable mail. If you ever mail anything to Palmetto, you need to be able not only to prove what you sent, but you need to prove when it got there if you're talking about whether or not an agency met a timeline to report something. Palmetto loses stuff all the time, frankly, and their mailroom is kind of notorious for misplacing things, and I've had it be a very critical issue in cases like for reporting a change in location. Well, we sent you an application and here's our tracking information showing it was delivered and it was delivered on time. So really your action is unjustified. And those that's a winning argument. If I can't prove those things, you're in a real pickle if you do end up revoked over something like related to reporting a change of location. Let's go to the next slide. All right, the enrollment and reporting obligations, you can find most of what you need to be aware of in 42 CFR 424.510. These are the obligations when you file an application. You have to fill that application out truthfully and completely. The person who signs that application, the authorized representative, is attesting that that information is accurate and that you're going to follow all of the applicable statutes, regulations, and program instructions. When you submit an application, whether it's through PACOS or on a paper application, be sure you're sending all the required attachments. There's a list at the end of the paper application, and there is a list generally in the supporting documentation section on a PACOS application. Things like copies of your license, copies of your accreditation, proof of your tax ID number, sometimes proof of funds if you're a new home health agency, copy of a voided check for your EFT forms, things like that. If you leave application attachments off, it just generates requests for follow-up from Palmetto and kind of drags out the enrollment process. Only an authorized representative can sign an application. There's a definition of who an authorized representative is, and it can't be just anybody in the organization. Generally, it has to be an owner or an officer of the company. They usually take your word for that, but if the person who signs the application doesn't show up in the individual ownership and managing employees section of the application, they'll kick it back. They're not an authorized signer. If you're utilizing some kind of outside credentialing service or a contractor to help you prepare applications, I highly, highly, highly recommend that you, as the provider, protect yourself by never letting anybody sign an application for you. It's absolutely important that whoever's name goes in that authorized rep signing for the application, they need to review that application, make sure the information that's there is accurate, and know what they're representing to Palmetto and the Medicare program when they submit that application. There are lots of ways to get this accomplished. Palmetto will now accept Adobe Sign and DocuSign signatures on applications. So there's no reason, if your outside credentialing service that you're using to help you with this stuff is remote from where you are, there are ways to get this done where the right people can sign documentation. In PACOS, there's a process for a staff user who's been appointed to create PACOS applications for a provider can request e-signature. As part of that e-signature process, the person signing off on it, who's the authorized rep, has to review the application. So don't just give some of your login credentials to PACOS and say, go through this application for me, sign it on my behalf and send it. Really, really not a great practice and can really create problems for you from a liability perspective if something on that application is wrong. Let's go to the next slide. Site visits. This is part of the enrollment process as well. It can be they can be random, or they can be part of processing an application, especially when you have a change in location. These are just operational status checks. They are not surveys, but they are generally imposed on both revalidating home health agencies and hospices and new home health agencies and hospices. So it's important that if you fall into those categories, or you're moving locations, that you understand, especially for new, I see this a lot with new initial applications, and I see it sometimes with either changes of ownership or with changes where you have a change of majority shareholders or members of an LLC. If you buy a business that doesn't have patients on it and you're going to move that business, or you're kind of ramping up business for whatever reason, when you send an application and you're representing that the practice location that's on that application is operational, that it is open for business, which means you need to have people there answering the phone, the lights are on, the door is unlocked during the posted hours of operation. If you're not, and that's what these site visits are looking for, are the lights on and is anybody home during the hours they say they're going to be there? If they come to do your site visit and they can't find the agency or it's closed, that's an automatic return to go. Return to the beginning of the process. They will kick you out. If they do a site visit of a currently enrolled provider, let's say you're revalidating, and they can't validate your location, you're not there, lights are not on, nobody's home, they'll try twice generally, different times of the day. If they can't validate it, you can get revoked. So it's really important that as part of this overall enrollment process that you understand site visits can happen, and it's really important, and we'll talk about this a little bit more in a minute, but it's really important that you have a coverage policy in place for your physical location. Also be aware of fingerprint-based background checks are going on for new hospices and new home health agencies, or those that are revalidating if their direct owners and managers have not been fingerprinted before. Fingerprinting is only required upon request by the contractor. And when I say the contractor, I mean Palmetto. There is a specific fingerprinting service that has been retained by CMS, and it's called Accurate Biometrics. They don't do your fingerprinting, but they process all the fingerprinting requests. So If you are a new home health agency or a new hospice agency, or for example, if you're a buyer of a home health or hospice agency, you can anticipate that the owners are going to have to be fingerprinted, and you need to be on the lookout for that fingerprinting letter or letters to come during the initial processing of an application. Kind of a tricky thing with fingerprint checks, they don't email those requests like they do other development requests on applications. They send a paper letter by US mail with no tracking. So, and they generally send it to the practice location. So it's really important that you be on the lookout for that letter. And if you get, 60 days into waiting for an application to be processed and you haven't heard anything and you expect fingerprinting to be happening, somebody needs to be contacting Palmetto to find out if those letters have been sent and follow up. All right, let's go to the next slide. Okay, this is a quick summary chart. You can actually print this page out when you get the handouts. This is the timeline sort of when you have to report changes to your enrollment record. Changes of ownership have to be reported in 30 days. There's a legal definition of change of ownership. Generally, it means in our world, asset transfers. So Company A is buying all the assets of Company B, and that includes their Medicare certification. Changes of control, which in my brain always means equity acquisitions, meaning individual ownership group has bought all of the membership interest or shares of an existing provider, and they own that provider and the entity and tax ID number after the end of the transaction. Those have to be reported within 30 days as well. Changes of authorized or delegated representative, report in 30 days. Final adverse legal actions have to be reported. Generally, if it involves a federal or state license, revocation, or suspension, they have to be reported in 30 days. Any other kind of final adverse legal action is 90 days. If you're changing, adding, or deleting a practice location, you have 30 days to report that after it happens. All other changes are reportable within 90 days. There's a regulation where you can refer to all this information. They do make changes from time to time. It's at 42 CFR 424.516. Let's go to the next page. All right, revalidation. I think if you've been in the Medicare program at least 5 years, you should have received and been through a revalidation process. If you haven't and you're fairly new, generally speaking, all home health and hospice agencies are required to revalidate every 5 years. The requirements are found at, I put the regulation in here, it's at 424.515. If you miss the deadline to revalidate, they can put a hold on your payments, they can stay your enrollment, or they can deactivate you. There is a website where you can go and check if you're due for revalidation, and if you're due within 6 months, you will show up on this list. If you're not due within 6 months, you either may not appear on the list, or what you'll see when you go check it is it'll say TBD, to be determined. Once you see your business show up on this revalidation list, start working on the revalidation. Don't wait until you're really super close to the deadline. If you, for whatever reason, you're supposed to get a reminder email or letter 2 to 3 months before your revalidation due date. Sometimes those fall through the cracks. So I tell folks, listen, there's no, it's sort of institutionalize a process to go and check your revalidation status. Either, it also shows up in PACOS, by the way, on this revalidation database that I gave you the link to up above, or on PACOS, check every 6 months and just see if anything's changed. If you haven't completed a revalidation and you get the email or letter 2 to 3 months before your due date, if you haven't received that, generally it's because either the letter got lost somewhere, an email went to somebody who's no longer with the organization, or your correspondence and email addresses are not up to date on your enrollment record. All of those are issues. But you, as a provider, can go out and proactively look and see what your revalidation status is at either this data.cms.gov site or within PACOS. There's a fee to revalidate, $730 this year. That changes every year. PACOS, if you do an application through PACOS, will prompt you to pay before submitting the application. If you do a paper application, it is on you to go pay the fee, print out your proof of payment, and send it with the application. If they don't get it with the paper application, they will ask you for it. If you miss your revalidation deadline, I don't want you to assume the worst. What I want you to do is prepare the application and send it as quickly as possible. You may be deactivated for a short period of time. There may be a gap in enrollment. If that happens for some reason, I highly recommend you reach out to your favorite healthcare council and see if they can help you with that situation. Let's go to the next slide. All right, traps for the unwary. Sort of things we've seen over the years that complicate or result in adverse things happening. Update every enrollment related to provider, owner, or managing person. When you update one, for example, I have a client that owns a hospice and a home health agency under the same company, different enrollments. Every time there's a change in their ownership, a small change in ownership percentages, one person buys a partial interest from another person, I have to report that on their hospice enrollment. I have to report that on their home health enrollment. We've had similar situations where I've got, clients that own, home health, hospice, and they have a Part D palliative number. You have to report them all across the board. You can't just do one. And unfortunately, PACOS is not sophisticated enough yet to allow you to do kind of a universal update for all enrollments under a particular, for example, tax ID number. We hope at some point in the future that might be the case, and it had been proposed as part of an overhaul of PACOS, which I saw not too long ago. They put on hold indefinitely. So just keep that in mind. If you have multiple businesses under the same tax ID number with separate PTANs, if you have to update one with something like ownership information, you're going to have to update everyone. You have to be able to prove, like I said before, delivery before a deadline if you're trying to defend a revocation action. So it's really, really important that you use trackable mail for anything you send by mail to Palmetto. If you're submitting things by PACOS, my suggestion is you can print a submission confirmation when you submit a PACOS application. Print and save that, and also save a copy of the application you submitted. There are links to do both of those things on the final submission page. After you hit submit, you can print that confirmation of submission. You can print the submitted copy of the application. I've already said if you mail something, use trackable mail. That's generally certified mail, priority mail, or express mail. If you miss a deadline, it's very common for people to call me up and say, oh my gosh, we had this change in our enrollment and we didn't meet the deadline to report it. What do I do? Am I going to get revoked? And my answer is, if they haven't contacted you to do anything at this point, you're probably fine. Let's prepare and send the application immediately. And in most cases, you'll be fine. Let's go to the next slide. All right, I think it's the last slide I'm going to cover. Felonies. We talked a little bit about this earlier. CMS is really, really strict about reporting felonies, and they will take action if they identify an owner or managing employee with a felony within the last 10 years. Any felony conviction that an owner, managing employee, officer, or director of an organization has had is reportable. Not every felony results in revocation, but absolutely have to report every felony. And there's a typo in here. Any felony within the previous 3 years is reportable. It's actually within the previous 10 years. Applicable regulations then say CMS can use its discretion to determine if a felony is detrimental to the best interest of the Medicare program and its beneficiaries, and whether they should revoke your organization based on that person having a felony conviction. There are 4 categories that CMS automatically considers detrimental and that can result in revocation. That's felony crimes against persons like murder, assault, rape, felony financial crimes like income tax evasion, insurance fraud, any kind of healthcare fraud conviction falls into that category. A felony that placed the Medicare program or its beneficiaries at immediate risk. These are things like criminal neglect or misconduct. And any felony that would result in mandatory exclusion by the HHS Office of Inspector General. That usually includes the 3 categories above, but it also includes things like unlawful manufacture, distribution, prescribing, or dispensing of a controlled substance. So if you have an owner, managing employee, officer, or director that has a felony conviction in the last 10 years, whether it's state or federal, they likely need to be removed from your organization and your Medicare enrollment record. if you got a revocation notice on something like this, and you can submit proof within 15 days of getting that notice that that person wasn't there and you'd already removed them, you just forgot to report it, then generally we can convince CMS to rescind the revocation. But it's a very time sensitive, and you have a very short window to take care of things like that. That my advice is screen your owners, managing employees, directors, and officers very carefully, and make sure this isn't going to be a problem, and you'll never have to deal with this problem. Let's go to the next slide. All right, Ashley, I think you're going to take it from here.
Thank you, Jennifer. So now we are talking about operational issues for revocation. Specifically here, we're looking at reason 5, which is on-site review, and reason 2, an excluded or debarred person. So reason 5, on-site review, we used to see a lot of revocations based on site reviews. It's still an issue. We kind of see these revocations come through in waves, but it's very important that you have signage for your agency, that you're located where you say you're located in your 855, and that you have regular business hours. You post those hours, you are actually there and operational during those hours. You have somebody there answering the phone at the desk. Make sure that person doesn't just leave for lunch. You need to treat your office like it is, in fact, a true office. If CMS showed up for a site visit and the office was closed, somebody put a note on there, out for lunch, back in 15 minutes, they're going to consider that you weren't operational or closed. So it's very important that you do, in fact, run those offices like offices. You have regular business hours. You're open during those posted business hours, and that you have signage. They're able to find the office. Another issue we're seeing, excluded or debarred from the federal program. If any provider or supplier, owner, managing employee, authorized or delegated official, medical director, supervising physician, or other healthcare professional is excluded or debarred from Medicare, Medicaid, or any other federal healthcare program, or if any of those people or entities are debarred, suspended, or otherwise excluded from just in any other federal procurement or non-procurement program or activity, you can be revoked for that reason. So it's very important that you are screening all of your employees, making sure that they are not excluded from participation. It's different than a background check. Make sure you actually are checking the LEIE, the GSA SAM, all the available state lists to ensure that people aren't excluded. You need to check their, if it's somebody who has had a prior name, if they've gotten married and changed their name, you need to make sure you're checking all iterations of that, because you can be revoked for that reason as well. And I'll talk about this a little bit more, but there's a specific way to try to fix that issue. But it is a major reason that people get that we see people get revoked. Next slide. Oh, there we go. Okay. In addition, state licensing and federal Medicare regulations require home health and hospices to have signage in post hours of operation. Like I was just saying previously, so please make sure that you have that signage available along with those operational hours, that you also have emergency contact numbers available just in case somebody does show up, that there's somebody that they can contact if nobody's there. Just spoke about this, again, treat your office like a retail business, plan for emergencies. If your regular receptionist is sick, who's gonna cover the office? You need to have a contingency plan. You can't just decide that you're closed for that day. But in Murphy's Law, that's the day that they're going to show up and do a site visit. And also make sure you actually answer the phone. We did see, we have seen cases where a site visit was actually done via phone, and the provider, it was during a very busy time, and the provider did not answer the phone timely, and several calls were made. They weren't answered timely, and there wasn't a way to leave a message, and they were revoked based on that site visit that was attempted via phone. So very important that you answer the phone, you have a message machine that is able to receive messages, and that you do return any messages you receive in a timely fashion. Next slide. Okay, and to talk a little bit more about exclusion, I'm going to touch a little bit about affiliations here as well. So I know Jennifer previously, touched on affiliations, but it's very important that you are, in addition to screening for exclusions, that you are looking at your owners, your managing employees for things that can be considered something that would be an undue risk to the program. Have they ever worked at a company that is revoked? Have they ever worked at a company that owes an outstanding debt to Medicare? Those are things that you can't screen for, so it's really difficult to identify that information. But I will say we have seen an increase in the number of cases where CMS is using its authority to revoke agencies because of a affiliation issue. For example, I've seen situations where a hospice has been revoked because a medical director was affiliated with another revoked hospice, there's a specific way to take corrective action. I'll talk about that in a second. But it's very important to make sure you understand the individuals who are being considered managing employees. And CMS does consider for hospice as a medical director to be a managing employee, even though, I would take the position that, if that person is a 1099, they're not really involved in any management decisions. Is that really a managing employee? That's an argument you can make, but you don't want to have to be in the position to make that argument, right? You want to make sure that the individuals you are contracted with, the individuals that are your owners, your managing employees, those people don't have situations that would be considered to pose an undue risk to the program, which includes an outstanding overpayment to the program. It includes an affiliation with a company that is currently revoked, somebody who is excluded or debarred, people who may have licensing issues, all of these issues. So you need to make sure you are doing background checks and you are doing exclusion checks. If you do identify a person who is excluded, or maybe you do uncover that somebody has an affiliation, you need to terminate that relationship because it's going to pose a risk to your agency. If they are excluded, you may need to do some sort of refund to the government, and there is a way to do that. If you get revoked, then you need to remove the tainted person immediately and deliver proof to CMS within 15 days after receiving the revocation notice. That is specifically in the regs for revocation that you can correct, specifically for exclusions, a revocation based on an excluded owner or managing employee via that method by terminating them immediately and providing proof within 15 days after receiving the revocation notice. So very important that you are opening mail from CMS, and if you do receive a revocation letter because of an excluded person, that you take action quickly, get that notice into CMS. We have, like I said, we are seeing affiliation revocations for the same reason. So we are in the process of testing cases where we are utilizing this same method of refuting a revocation based on affiliation by utilizing this guidance under the exclusion of they were terminated and providing proof within 15 days. So you just need to make sure you're acting quickly when you're getting some sort of notice like that. And also, to prevent situations like this, you really need to standardize your hiring procedures. Again, like I said previously, you need to make sure you're screening for exclusions. You can always contract out to do the exclusion screening. Just make sure that the company that you're hiring isn't just doing a background check. They're not just doing a licensing check. An exclusion check is a specific check of the LEIE, the SAM, and the state list. That is a completely separate check for an excluded person. Exclusion is something that happens after there's a final adverse action. I would also recommend that in your hiring practices, you're asking these people, have you ever been affiliated with a company that owes a debt to Medicare? Have you ever been affiliated with a company that's been revoked? Like I said previously, there's not a way to screen for that, but you've got to try to protect yourself. And if you do end up subsequently getting a revocation letter, that's evidence that you are trying to identify this, and this person misled you when they, didn't respond appropriately on their application or their,
Just to add to that, Ashley, I think if I recall correctly, the regulation says you have to make reasonable efforts to identify these affiliations with disclosable events. And what we've generally told people is, we're happy to work with you to help you develop a list of questions to ask, for example, when you're hiring a medical director. what do you need to know about them? Well, let's develop a standardized list of questions. You want them to respond, preferably in writing, sign off on it, date it, so that you have something in your file that shows you did your due diligence.
That's right. That's right. Thank you, Jennifer. And make sure you're doing all this before you hire the person. Don't, hire them and then start doing all this due diligence. Incorporate it into your screening and hiring practices before they're actually an employee. And like I said previously, if you do identify an issue, obviously we want to take action. We just don't want to ignore it. But I would recommend reaching out to legal counsel if you do encounter a situation where you have been affiliated with somebody who seems to be problematic. They may have an affiliation revocation risk issue, or somebody that's been excluded. I would absolutely recommend reaching out to counsel to kind of navigate the path forward from that. Next slide. Oh. I think one more. There we go. Thank you. So this is a big revocation area that we are seeing. Abuse of billing privileges, specifically a pattern or practice of billing errors. I would say probably within the last 3 or 4 years, we've seen CMS use this revocation reason a lot. And it really seems like they have just really broadened their use of this, this revocation reason. So just for some background, CMS has a discretion to determine if there is a pattern or practice of billing errors. As of 2022, the factors that were to be considered were the percentage of claims denied during the period under consideration, the provider's history of final adverse action, nature of any such actions, the type of billing noncompliance and the specific facts surrounding said noncompliance, and then, of course, my favorite reason, or my favorite factor, any other information regarding the provider or supplier's specific circumstances that CMS deems relevant to its determination. So basically anything else it wants to consider, it has the authority to consider in determining whether or not a provider has a pattern or practice of billing errors. This revocation reason is specifically driven by data mining and audit activity by Max and UPIC. So, they're doing investigations and reporting back to the MAC about the results that they're seeing. If they're doing a subsequent audit, is there an improvement in those claims, or is it more of the same? The problem with this revocation reason is that you really are having to pursue 2 appeals at the same time. A lot of times there is a claim appeal audit that needs to be appealed and a revocation appeal, and you're revoked while you're fighting these audits. Which if you are heavily reliant on Medicare, you are in a really hamstrung situation financially while you're trying to take on what are really 2, rather substantive appeals. And it can just be a very expensive and stressful situation because, the administrative appeals process is not necessarily a fast process. We have some examples for you. Hospice was suspended for a credible allegation of fraud and then revoked. Repeated UPIC audits. This is the one that when we initially saw CMS ramping up its use of this revocation reason, we saw a number of cases where there were repeated UPIC audits, typically 3 in a row with a high error rate that led to revocation. It's almost like a 3 strikes you're out approach. And then also we are now seeing PPEO audits after a change of ownership or 100% change in shareholders or members. I'm going to talk a little bit more about each of these as we go on, but there are, specific things that, you need to consider. And that my biggest message to everybody on the call today is that if you get a claim audit, you get a UPIC decision, you need to appeal it. Even if there is a de minimis amount of an overpayment, it's very important that you assert your appeal rights and take those claim appeals through the administrative appeals process. Next slide. So this is some language that comes straight off of a TPE result letter and language that comes off of a UPIC result letter. They are putting the messaging out there that you can be revoked. So the language from the TPE result letter, if after 3 rounds of TPE review, there are continued high denials, Palmetto GBA will refer the provider to CMS for additional action, which may include 100% prepayment review, extrapolation, referral to a recovery auditor, etc. And then in the UPIC letters we're seeing, in addition, we want to remind you that under the reg, we're authorized to revoke Medicare billing privileges under certain conditions. In particular, we note that CMS has the authority to revoke a currently enrolled provider or supplier's Medicare billing privileges if CMS determines that the provider or supplier has a pattern or practice of submitting claims that fail to meet the Medicare requirements. So they're putting it right out there for you in their decisions. We have the authority to revoke you if we determine that you have a pattern or practice of billing issues. You know, here's your education. They consider that UPIC decision education. And if there isn't a change in your billing practices and you don't appeal that decision and have success on the appeal, then they'll come back, they'll do another audit, and if there's no change, there's still a high error rate, they're going to start to consider that a pattern or practice of billing errors. Next slide. So how do we prevent this? Like I said previously, if there is a claim error and you can fix it, fix it. Don't just allow issues to remain. You need to fix problems. If you are notified that there's an issue with how your documentation is being prepared and it needs to be corrected to meet the coverage requirements, fix the documentation. Don't fix it retroactively and inappropriately, because that can be considered fraud, but you need to take corrective action so that going forward, your claims meet the coverage requirements, so that you can show that you're trying to be a good corporate citizen. You've been educated, and now we're taking the right steps moving forward to make sure that we're in compliance. You need to have a compliance program that is suitable to your business, and that compliance program needs to include regular claim auditing. That can be internal claim auditing. You can use an outside company to do outside reviews, but you need to have some sort of QA process to look at your documentation and make sure it's meeting the coverage requirements. You should also know your denial reasons and work to reduce their frequency. Provide feedback to your clinical staff on their documentation. A lot of providers, they're not getting educated about how to document when they're in school. That's something that is just kind of institutional knowledge that they learn as they go. It's really important that you educate these providers on what you need to have to meet the coverage requirements so that you are in a good position if you are in a claims audit. Make sure you do a deep dive on your entire claim cycle, as this can be a part of your compliance review. You need to look at the records, the claims, the ERA, is everything matching up? You can get some paper ERAs from Medicare and other payers and verify that they match what you received electronically. A lot of times we see there are issues between the EMR system, the clearinghouse, something goes awry. You need to make sure all of that information is accurate, because we do see, providers actually, unbeknownst to them, have overpayment or billing errors because of the way that their systems are set up and not necessarily talking to each other the way they're supposed to. And again, like I said, appeal your denials. Appeal your individual claim denials, appeal a UPIC decision, appeal a SMRF decision. You need to appeal your denials. If you do not appeal those denials, then CMS is going to take the position that you agreed with what they said, even though you may just be paying it and not appealing it because you don't have the resources to deal with, hiring an attorney to fight an appeal. You need to appeal those denials because they will take the position that you agreed with that decision. And if you don't make any changes based on your documentation and they come back and look again, it's a high chance that you will subsequently get revoked, just because of the position that CMS seems to be taking on this specific revocation reason. Next slide. Okay, so the PPEO audit. This is something I would say within the last, a little longer than 6 months, maybe 8 months or so, we have seen CMS use PPEO audits in connection with the pattern or practice of billing errors. PPEO is active for hospice initial enrollments, CHOWs, 100% change in shareholders, members in Texas, as well as California, Nevada, and Arizona. I'm sure if you are an agency that has recently gone through a change in ownership or change in shareholders, you are well aware of what the PPEO process is. For those of you who are not, very important you are aware of this. because it honestly has been a very aggressive process for a lot of providers. The MAC for the jurisdiction that you're in, if you're in Texas, is going to be Palmetto, is going to review a sample of claims after one of the events that's listed in red that I just read out. We have seen a wide variability in how the MACs are implementing this. There's no real detailed policy or direction on how the MACs are really to implement the program. So for example, Palmetto in Texas, we've seen that they'll review 10 claims. And then if those don't go well, if the provider fails, then they'll review an additional 10 claims. It's very similar to a TPE process. Repeated failure in the PPEO could result in a referral to a UPIC or a revocation. But we're seeing very small subsets of claims in these PPEO reviews.
Yeah, just in contrast, Ashley, you know, if you're in TPE, they're going to look at somewhere between 20 and 40 claims.
Mm-hmm.
Which gives you, you know, you can fail a 2 to 4 of those and still pass TPE. If they only look at 10 claims and you fail 3 of the 10, you're automatically in, you know, in the red zone. So it's distressing to see how small the claim reviews are.
That's right. That's right. And I'll say, if these are prepay reviews, which typically they are, for TPE and for PPEO, when you're getting those decisions back as you're going through this process, appeal the decisions. Don't wait until you get through the end of a TPE round or the end of your PPEO round. When you get those claim decisions back, go ahead and get them going in the appeals process if they're unfavorable. In California, Nevada, and Arizona, NGS is the MAC out there. We've seen an example where there was a requested all claims for a month for a large hospice in Arizona, and they held 100% of the payments until those claims were reviewed. I mean, if you're a large hospice provider, and I mean, y'all know how big a hospice chart is. I mean, there's thousands of pages. And for a MAC to request that sort of documentation, I mean, it almost just demonstrates that they don't even understand what they're asking for.
Yeah, we got that one fixed, by the way.
So if you get something outrageous like that, please reach out to healthcare counsel that can try to help you kind of fix that situation so that you're not trying to submit thousands and thousands of pages of documents that the MAC realistically doesn't want. They just don't understand what they're asking for. Another example, you know, and this goes to kind of show that there's real inconsistency in how this PPO process is working. We have the same MAC where there was a small sample of claims, 8 claims that was reviewed for a hospice in California, and a 50% error rate was identified, and that hospice was revoked based on that 50% error rate on those 8 claims. And it was like over like a 6-month period. So it was very, very aggressive response to a very small subset of claims, you know, not even 100% error rate. So very important that if you are in the PPEO process, you are taking the time to organize those charts, making sure you've got all the pieces of documentation that you need, and that you are appealing those claims as they come in if you've got an unfavorable decision. I mean, it is critical because you may not get a lot of claims to justify the services that you're providing and to kind of offset that error rate. So you need to take these audits very seriously. There have been very serious repercussions where, you know, we've seen somebody only go through 1 round of PPEO, 8 claims get revoked. We are still taking that case through the administrative appeals process and fighting CMS's use of its discretion. But for right now, I would tread with caution if you are a provider that's going through the PPEO process, and take that process very seriously, because CMS is being very aggressive in its use of the pattern or practice of billing errors revocation authority in connection with these types of audits. And I need to move on. I'm sorry, I'm talking too much and we're running low on time. So let's go to the next slide. Okay, so I want to take a few minutes to kind of talk about the appeal process, what happens if you do get revoked. So if you do receive a revocation letter, you need to identify the effective date first. Sometimes, especially if it's based on a felony, for example, it can be before you receive the revocation letter, or if it's based on a site visit, it can be the day that they did the site visit. So you need to make sure that is the first thing you look at. Is it a revocation that is being retroactively applied, or is it a revocation that is going to take effect 30 days from the date of the letter, which is for revocation reasons that are outside of site visits, felony convictions, and exclusions. That's typically what we see. It's taking effect 30 days from the date of the revocation letter. But again, there is no stay of a revocation. So you are going to get revoked on that day 30, even if we're appealing the revocation. It doesn't matter if you're appealing. You're still going to be out of the program the entire time you are fighting that revocation. Something else that's important to think about is that Medicaid does have the authority to revoke. We don't always see that happen immediately. We do in some situations. I've seen it happen in some states that sometimes you go through the administrative appeals process first and then that occurs, but they are supposed to revoke you. Private payer contracts are often require that you report the revocation to them, and you typically also need to report it to an accrediting body if your agency or business is accredited. Also, we do see these get reported to the NPDB as well. So something else to keep in mind, that there could be a report to the NPDB as well that you need to respond to. Next slide. So if you do get a revocation letter, you need to immediately call your healthcare counsel or find a healthcare lawyer that can help you. You need to discuss the appeal and alternative business arrangements that can help keep you in business. This is not the time to do it yourself. This is your business that is on the line. There are very tight appeal deadlines. There are strict rules on the submission of evidence, so it's very important you take this seriously and take action promptly so that the attorney you're working with has time to prepare a proper appeal. You have 60 days from the date of the revocation letter to file a reconsideration appeal. In some instances, for example, if you are revoked for noncompliance, then you can also submit a corrective action plan, which has to be submitted within 30 days. But it's important to note that if you are revoked for that specific reason and you are submitting a corrective action plan, the corrective action plan doesn't stay the timeline for the reconsideration. So you need to file the corrective action plan and then also file that reconsideration appeal while the CAP is pending. If the CAP is successful, then CMS will just kind of say that the reconsideration is moot. But it's very important that you know that filing the CAP does not pause your reconsideration appeal timeline. If you have an affiliation revocation reason or an exclusion, suspension, debarred person, again, like I said previously, take immediate action, terminate that person immediately, and then get evidence over to CMS or to the MAC. It can depend on who your appeal goes to. That'll be on the revocation letter within 15 days to show that person has been removed. If you need to make a report to the OIG because of an exclusion, that's something that you can do with counsel. But the most important thing for the revocation is to get that evidence in within 15 days. You also need to develop a plan for your business. Alternative business arrangements, you need to review your payer contracts, develop a plan to address reduction of staff while retaining necessary personnel while you transition patients to new providers, and really conduct a realistic financial analysis of how long you're going to be able to stay in business and continue operating while you are revoked from Medicare. Because it can take, 90 days to get a decision on that initial appeal. Next slide. All right, I just went over corrective action plans. Again, 30 days to file those. You can't fix a failure to report, but you can address mistakes that the contractor made, like failing to acknowledge an update that you sent. You can also utilize this sometimes for DME or IDTF, standard violation issues. Usually takes 30 to 90 days to get a response. Reconsideration, again, you have 60 days to file. The most important thing about reconsideration is this is your evidentiary milestone. If anything you want considered in your appeal needs to be submitted with your reconsideration appeal, that first appeal of your revocation letter. So everything you want considered needs to be in, which is why it's important to get your attorney involved early so that they have time to get all of that documentation from you and get it prepared and incorporated into a cohesive appeal. It does typically take about 90 days to get a response back from either the contractor or the provider enrollment oversight group, whoever the appeal is supposed to go to. But it's important that you make all of your arguments, your factual and legal arguments there, and that you address all of the revocation reasons, or you will not be able to preserve those for a subsequent appeal. Next slide. All right. If your reconsideration appeal is unsuccessful, you do have additional appeal opportunities. You can go to the Departmental Appeals Board, the Civil Remedies Division. You can file a request for a hearing. That's going to be due within 60 days of the reconsideration decision. I will say this is like a formal court procedure. It includes briefing. There is an attorney assigned from CMS, from the regional office, and each side briefs the case and provides evidence. It can make motions in the case as well. You can request a hearing to cross-examine witnesses, but the judge can also decline and decide the case on the briefs. The rules state that they try to resolve these cases within 180 days, but it can take longer than that. CMS will consider settling cases at this stage, but you have to show a compelling reason why the case should be settled. Really important to have an attorney involved at this level. If you did not get somebody involved at the earlier level, obviously that's the preference, to get them in at reconsideration, but I highly recommend an attorney if you're going to be filing for an ALJ. If your ALJ appeal is unsuccessful, you do have an option to appeal to the Departmental Appeals Board Appellate Division. This has appellate rules that apply. Errors of law, substantial evidence. This is typically a case that is reviewed on the record from the administrative record from the ALJ review. And of course, you can always also appeal to federal court if your appellate division decision is unfavorable. That typically needs to be filed within 60 days of the lower level decision, and you must go through all the prior steps first. You have to exhaust your administrative appeal rights before you go to federal court. That is always an option. There can be, a substantial cost associated with filing in federal court. Next slide. Okay. Quickly, I just want to talk about the stay of enrollment. This is relatively new. CMS issued an MLN Matters article that indicated that contractors can start using this as of May 30th, 2024. I've only seen it a handful of times since then. It is less burdensome than an actual deactivation or revocation of Medicare enrollment. A stay is essentially a preliminary interim status that is kind of a pause in enrollment. It does not require a full initial application as a new provider to remove the stay and reactivate billing privileges. This typically becomes an option if you've been non-compliant with at least one of the Medicare enrollment requirements. It can be remedied, but you can remedy it by submitting an enrollment form, so submitting an 855 with the correct information. So some examples are if you fail to timely report a change in address, fail to timely revalidate, failed to report the deletion of a managing employee, you can utilize this, submit that corrected enrollment form, and instead of being deactivated and having a potential gap in enrollment, this can correct that and you won't have a gap in your enrollment. You remain enrolled during the stay. Claims will be rejected during the stay period, but again, if you get reactivated, you're not going to have a gap like you would if you were deactivated and then there was a time period where you had not submitted a corrected 855 yet. This is not considered an adverse legal action. The stay is no longer than 60 days, but it can be imposed multiple times. So if you have an issue with your revalidation, you fix it, you had to stay there. If you then subsequently have an issue with the failure to report a change of address, you get another stay. So there's not like a one-time only thing. I've only seen this being utilized so far in connection with failures to revalidate, but I expect that we'll see more of it. But it is important to know that this is something that we're seeing. It's a great option because the deactivation, obviously, if you have a gap in your enrollment, you're lost revenue that you didn't have to try to fight over. So it is something that I, keep an eye on your mail. If you do see a revocation letter with a stay, make sure you get that corrected immediately so that you do not have a deactivation issue. Next slide. All right, I think that's it. Do we have any questions?
I don't see any questions. All right, well, thank you so much to our presenters, and thank you to all of our attendees for joining us today. Again, I will be sending a copy of the PowerPoint slides tomorrow, and if you have any further questions, please feel free to reach out to Ashley or Jennifer with the information provided on the screen. Thank you so much, and I hope you all have a great Wednesday.
Thank you.